the future. I fully agree with your remarks. Actually, one of the biggest challenges for an arbitration institute and the institute in Denmark as well is how to build a bridge between mediation and arbitration. With other words, how to always offer the different ways to solve disputes which the parties ask for. Maybe in 10 or 15 years from now, it may not be arbitration that's in demand among the companies, but let's see about that. Our next speaker is Bruce Harris. He's going to give us the Cedric Barclay lecture, which I personally look very much forward to. I guess that no further introduction of Bruce Harris is required, so I'm just happy to leave the floor to you, Bruce.
David Marchowski's reference to Your Grace was, of course, a reference to Jon Stockholm, who had asked to be referred to in that way. But it reminded me that many years ago, the great Lord Mustill, when he was first a judge, was asked by somebody, "How do I address you?" "Oh," he said, "Your Holiness will do."
Thank you for the advice.
For the last 25 years or more, Manfred Arnold from New York and I have managed to keep ICMA on track and going and keeping its essential ethos. So for me, the fact that Manfred, due to ill health, is unable to be here for this Congress leaves a great emotional hole. And I'm going to dedicate this lecture to him and to his very supportive wife, Susan. Noting also the pity that we can't have the current president of the SMA, Robert Shaw, and his wife, because his wife is also recovering from major surgery. So to be asked to give this lecture is for me an incredible honour and a correspondingly heavy burden, for I follow 9 earlier lecturers, each of whom had infinitely greater qualifications, and I feel far, far more to offer than I. So it was a huge shock when, in the summer of 2016, Clive Aston, on behalf of the steering and topics and agenda committees, telephoned to ask if I would take on the task. I mentioned the invitation to a lady friend who had attended the first Cedric Barclay lecture in Vancouver, given by Michael Mustill almost 25 years ago. I said to her, "I bet you never imagined that I would be asked to do this job in your wildest dreams." And she looked at me for a moment and she said, "Bruce, you never feature in my wildest dreams." But as I started writing, it was almost New Year's Eve of 2016. At that stage, the lecture had to be ready by the end of February 2017 so that it could be included in a new bound volume containing all 10 of the Cedric Barclay lectures to be made available at this Congress. And I'm happy to say those volumes have arrived, and they will be available, I hope, outside when we break for coffee. But at that point, I didn't know what I was going to say, despite having worried about it on and off over the previous 4 months. And there had to be every likelihood that by the time the Congress came round, 9 months away, I should want to say something quite different. But as it happens, probably due to laziness, I don't. The writing situation was not helped, though, when in mid-January, Philip Yang told me that I had even less time than I thought, only until mid-February. Now, many of my predecessors in this role have been great jurists, and understandably, they have dealt with the law. As a non-lawyer, I do not intend to trespass on that territory, a decision the rightness of which is shown by the fact that I am, I believe, the only maritime arbitrator to have been told 3 times by the House of Lords that an award I made as sole arbitrator was plainly wrong. One early thought I had was to look back over the 40 or so years in which I've been arbitrating, of which some 37 have been full-time, to see what's changed and just possibly to speculate on what might happen to maritime arbitration in the future, although prophesying is dangerous, as we all know, because the unexpected always happens. Now, my provisional title, whilst this idea was in my head, was 40 years on, Is This Progress? So I was momentarily peeved when at the LMAA luncheon in November last year, the speaker, Timothy Young QC, announced that his after-lunch speech was called 40 Years On. That is, as Tim said, the title of a brilliant play by a brilliant man, Alan Bennett, which was also my inspiration when thinking of a title for this lecture. This coincidence just proves that great minds think alike, although Tim's is infinitely greater than mine, as I'm sure he would readily agree. But as I got there first, I decided to stick with the title and to see what happened. Now, one of the dangers of any personal review of the past is, of course, a tendency to bang on about how things are not what they were, meaning generally that they're not as good as they were. Things Ain't What They Used to Be was the title of a very successful musical show in London in 1960. This is, of course, a perennial cry, which history shows us has echoed down the ages, probably ever since mankind became aware of itself socially. It's not easy to avoid this tendency, but I shall do my best. If, however, I end up sounding like a grumpy old man, some may say I've been like that for years, it's only because I speak as I find, and I would hope that you would not want me to do otherwise. Context, as anyone who has to interpret a contract well knows, is very important. So let me indulge in a lightning review of some of the changes that have occurred in the wider world before turning to the particular sphere of maritime arbitration. This is inevitably a very personal and very partial selection. You will have your own memories and your own milestones. But my first arbitration appointment was in 1974. Since then, we've had the first Star Wars movie and a whole lot of sequels and prequels, the death of Elvis, or at least his alleged death. That was in 1977. The introduction of the first mass-marketed personal computer, and shortly after that, the first laptops. The first test tube baby in 1978, the fall of the Shah of Iran and the rise of Britain's first woman Prime Minister, 1979, the loss of Great Britain's last independent colony in 1980, AIDS, the introduction of the mobile telephone, and now, apparently, more people in the world have mobile phones than have toilets. The discovery of a hole in the ozone layer, 1995, Denmark allowing same-sex partnerships, 1988, and it seems to me that there is a case for thinking that perhaps polygamy is now allowed in Denmark. If you look at the delegates list, you will find that Pia Schaumburg Miller has 2 husbands. Nowadays, of course, same-sex partnerships and indeed marriages are commonplace in many countries. The fall of the Berlin Wall, 1989, dissolution of the Warsaw Pact and of the Soviet Union. There have been various kinds of new disaster, some unquestionably to be so categorized, the Exxon Valdez, the Deepwater Horizon, 9/11 and all that followed, a devastating tsunami in 2004, the financial crash of 2008, the rise of Daesh, or IS, or ISIL, some of these categorizations as disasters may be more debatable. For example, the establishment of the European monetary system and the EU, the redefinition by President Clinton of the phrase sexual relations, the invasion of Iraq, and even the invitation to give this lecture. I deliberately avoid here mentioning certain events of the past year or so in case I become a victim of a Twitter campaign, whatever that may be. Other, perhaps more neutral events have included the establishment of the Internet in 1990, the opening of the tunnel under the English Channel, 1994, the cloning of a sheep, 1996, and the founding of Google, Wikipedia, and Facebook in the early 2000s, and now Instagram and the like. Now, I don't understand these things. Facebook, Instagram, Snapchat, Twitter, and what I do know of them I find very worrying. But I've tried to make friends by applying similar approaches in my own life. So when I walk down the street, I tell passers-by what I've eaten, how I feel, what I did last night, and with whom, and what I will do later. I give them pictures of my family, my dog, other dogs and cats, selfies of me in front of various landmarks, and doing everyday things. I listen to their conversations, I give them thumbs up, and I tell them I like them. And this has amazingly worked. I already have 4 people following me. 2 police officers, a private investigator, and a psychiatrist. But joking apart, it does seem to me that social media has had a substantial effect on communication, leading, despite appearances to the contrary, to a lack of real communication, and to a great effect on our beliefs. What appears on Twitter or elsewhere is easily taken as truth, however unlikely or palpably inaccurate it may be. One English commentator has referred to the collective dim-wittery, cliché dependence, and creative laziness of social media, and to an online moronocracy with a collective reading age of 12 and a quarter. I think the collective age is actually about 10. If memory serves me correctly, he wrote that before the United States presidential election. The modern and dangerous phenomenon is, of course, that of political correctness. This has gone so far that by the time this lecture is given, it would probably be politically incorrect to use the phrase political correctness. But let me give a few short examples from my home country, the United Kingdom. A school requires its pupils to sign a contract before they can play football. They must agree in this contract not to cheat, not to gloat when they win, not to be bad losers, and 14 other matters. Breach of a rule leads to a 3-day football suspension. In another school, teachers must not blow a whistle at the end of the break because it is too aggressive. Instead, they must raise a hand and wait for the pupils to notice. One suspects that breaks in that school last longer than the lessons. Thirdly, at a university in Scotland, a student was threatened with expulsion from a student union meeting for raising her arms. This was in breach of a policy that bans head shaking and hand gestures which denote disagreement. But students at the National Union of Students annual conference were urged not to cheer or clap so as to avoid excluding deaf people. Rather, they should use jazz hands. How that might affect the visually impaired was not made clear. For its part, Oxford University said that students who avoided eye contact could be guilty of microaggressions. The university was, of course, in turn accused of discriminating against autistic people. Last year, of course, saw some changes on the international scene that may have very profound and long-term consequences. For instance, the decision of the United Kingdom to leave the European Union and the election of President Trump. Both these events surprised the pundits whose job it is to forecast the outcomes of plebiscites. One imagines they may also have surprised some of those who were campaigning for such results. I suspect they will not be the only shocks that we shall be experiencing in the immediate future. Such occurrences reinforce my earlier point that it's very dangerous to prophesy, and they make me even more hesitant when it comes to guessing what the future may hold for maritime arbitration. Just as the Brexit and Trump votes were largely unforeseen, so it is impossible to know what they will lead to, not least because so many factors influence world events. Some feel that as a result the world has changed dramatically and will continue to do so. Others suggest that there is a parallel with 1848, when dissatisfaction with the then current leadership, a desire for more say in government, and an increase in nationalism led to effective insurrections in France, Germany, Italy, and the Austrian Empire, led by a coalition of reformers, middle-class intellectuals, and angry workers. Well, one sees the similarities, but whether the outcome nowadays, which was then in fact very little permanent change, whether the outcome nowadays will be the same is very much a moot question. But if there is one area where I think a fairly confident, if very general prediction can be made, I suspect it's in that of work. Unless something changes in a wholly dramatic and equally unforeseeable way, automation is likely to reduce very substantially the number of jobs, as we now know them, that are available. Most supermarkets operate principally now with self-checkout points. Amazon is opening shops that check you out with sensors only as you leave with goods under your arm. The British Retail Consortium estimates that by 2025, a third of all retail sector jobs will have gone. Driverless cars are increasingly with us. What will happen to taxi and similar drivers, of whom there are some 300,000 in our relatively small country alone, and to truck and heavy goods vehicle drivers, of whom there are over 4 million in the United States? The Bank of England reckons that half of the UK's 30 million jobs are at risk from automation. What will be the consequences for states, called upon as they will be, to support those made redundant, in addition to the increasing demands made upon state funds by constantly ageing populations? And what will be the psychological and social consequences for those who find themselves without work, and consequently for society at large? I venture no answers to these questions, but I suggest they are matters that should be of great concern. Now, let me return closer to our maritime arbitration home and consider what have been the significant changes in the shipping industry and how they've affected what we do. Again, I propose a selection that is inevitably subjective and undoubtedly partial. But it strikes me that at least in terms of effect on our business of arbitrating disputes, these have been some of the more important factors. Regulation first. In the past 40 years, every aspect of life has become subject to more and more regulation, as we know, sometimes to the extent that it threatens to suffocate. In one instance, I'm told by Patrick Seymour, in fact, ships collided, leading to at least one death because a captain's attention was focused on a bureaucratic control the next day for which he was preparing. But there's no doubt that many of the rules, regulations and laws introduced to govern shipping in the recent decades have served to reduce the number of undesirable physical incidents such as collisions, pollution, personal injuries and cargo damage, all matters that have more or less directly impinged on what we do. They've also created a number of arbitrable disputes, happily for us. Then we've seen a massive increase, already mentioned, in the use of containerization. Containers, of course, existed much earlier in the 20th century, but it was only after standards were introduced in the late 1960s and early 1970s and double stacking became acceptable that the practice of carrying former break bulk cargoes in containers and the consequent development in large numbers of specialized container ships really took off. Now we have container ships that are longer than the Eiffel Tower is high. Containerization has simplified many shipping practices, although it's given rise to new ones that are not always without their problems. And I suspect it's led to proportionately more cargo being carried on liner services compared to tramp ships than was previously the case. That in itself has tended to reduce the number of disputes that arise in relation to tramp ships. In addition, it's tended to reduce cargo damage, but it has in turn given rise to a few rather spectacular or serious incidents with which we've had to deal. And as a side effect, surpluses of containers have been used to help reduce housing problems in various parts of the world. On the other hand, the quantities of cargo moving around the world in ships have increased enormously, as have the numbers and size of ships. In 1975, something like 410 billion tons of cargo was shipped. In 1980, 5 years later, the figure was about 450 billion tons. But by 2013, that figure had doubled to some 900 billion tons. And the world's shipping fleet has more than kept pace, from about 580 million tons in 1975 to about 1,500 million tons in 2013, reflecting the surplus of tonnage that has so adversely affected the market in recent years. Now, much of that increase in ships, of course, was from ships built in the People's Republic of China, where from the late 1990s onwards, shipbuilding burgeoned. It's perhaps worth noting in passing that it's been estimated that in 2010, China was responsible for some 44% of the world's shipbuilding activity, whereas, of course, in the 1970s, it was Japan, Brazil, South Korea, and Europe, in that order, which were the leading shipbuilding areas. As we all know, rises in the price of steel in the early 2000s led to numerous disputes because shipyards suddenly found that their contracts were proving unprofitable. But the situation quickly reversed itself when the crash came in 2008. Ship owners who'd entered into contracts to build sometimes large numbers of ships at what seemed low prices Suddenly, they did that in order to take advantage of what they saw as a flourishing market. They suddenly were anxious to find ways of getting out of their obligations. And this situation has provided much employment for lawyers and arbitrators, at least in London. In my case, a far larger part of my time has been spent on shipbuilding disputes in the last 8 years or so than ever before. I've mentioned the increase in the size of containers and container ships, and of course, a similar phenomenon has been observed in the tanker trade. In my experience, this too has affected the number and type of disputes that come to arbitration. In the days of smaller tankers, we saw many more laytime and demurrage disputes, often turning on questions of pumping performance than we do now. Similarly, there were many more issues concerning matters such as tank cleaning than have come to arbitration in recent years. If I may digress for a moment, when the late, great Lord Bingham first became a judge, he sat in the commercial court. At the bar, he had not had a great deal of experience of shipping, and he was faced with one case about tankers in which counsel were referring to VLCCs and ULCCs, and he had to ask what did these acronyms mean. Once he was told, his response was, okay, so if I ever hear the phrase FLCC, I won't have to ask what it means, will I? Just to show that judges are human, occasionally. As well as larger vessels, there are now many more purpose-built ships and more in proportion to the total fleet than ever before. 40 years ago, cargoes were often carried in ships that were quite unsuitable. So, for example, grain might be carried in a general cargo ship with its limited-sized hatches and various obstructions in the holds, giving rise to innumerable disputes about all kinds of things with which we had to deal. This sort of situation, of course, still happens, but very rarely. Newer types of vessels have brought their own problems with which we've had to cope, not so much due to the nature of the vessels as to the new specialized areas of employment and the contracts that have been developed to deal with them. I have in mind areas such as the offshore industry. Oil rigs and wind farms require particular vessels for servicing purposes, and they create their own problems and their own disputes. Sometimes such problems are formidable. I was involved in one case concerned with the conversion of a very ordinary bulk carrier into the world's then most sophisticated pipe-laying vessel. Nowadays, that vessel is capable, after some further work, of laying pipes of up to 60 inches in diameter at a depth of almost 3 kilometers, and of carrying 220,000 tons of pipe and a crew of 420. So you can see quite a project converting a bulk carrier into her. The design, inevitably, was extremely complicated. There were problems at the yard doing the conversion, which led to the owners taking the ship away and completing her on the other side of the world at great cost and loss of time. The resulting claims and counterclaims totaled, if memory serves me, more than $600 million. In 1998, a very large sum, as it still is for most of us. The arbitration was so complex and involved, and there were so many documents in the case, that there were many tens of thousands of them, many of which individually ran to hundreds of pages. So the case was salami sliced, that was the phrase used. We took different issues at different times, and we made awards on each slice. 9 awards in all, before finally there was a settlement. In total, there were almost 300 hearing days, spread over nearly 10 years. By the conclusion of the case, I was the last man standing. One co-arbitrator had sadly died, 2 chairmen had resigned. The legal teams were completely different from those at the start of the case, but that was a truly exceptional matter, one that simply could not have arisen in the 1970s. In those days, that is, the 1970s, many of the disputes that came to arbitration concerned the calculation of laytime. I recall frequently having to pore over laytime statements, thinking about weather working days, time lost waiting for birth, one of the cases that went to the House of Lords and I got wrong. Reachable on arrival, another one. Whether in berth or not, arrived ships and the like. Such questions, or some of them, still come up from time to time, but far less frequently than before, partly because many have been resolved by the courts, and partly because of changes in the way business is conducted. Perhaps most significant over that span of time is the shift away from voyage charters to time charters, a shift which is reflected in the greatly increased size in Wilford and others on time charters, and the markedly less frequent appearance of books on lay time and notice of readiness and the like. But it's also reflected in the number of cases that have come before the English courts in recent years on off-hire and time charter indemnity questions. Technology, of course, has affected not only the way things are done, but also to an extent the nature of disputes, even if only indirectly. Whereas until the early 1990s, broking in London, shipbroking, was principally conducted face-to-face on the floor of the Baltic Exchange and by telephone, now brokers spend much of their time staring at screens, finding out what business or what ships are available, where and when, and then negotiating through various message services. Even email seems to be becoming redundant already. All this, in my view, has changed the nature of broking, and perhaps more importantly, of brokers. I have the impression, but as so often I may be wrong, that speaking generally, today's brokers do not have the same broad, down-to-earth experience of ships and shipping that they once had. If, as I suspect is the case, this leads to problems arising that have to go to arbitration, it's a good thing for us, but not for the industry. Another development that has been apparent is the rise of long-term charters, often tied to shipbuilding contracts, frequently themselves subject to subcharters, and not infrequently to further subcharters down a lengthy chain. Even short-term time charters themselves often lead to such subchartering. These chains can create formidable problems, for example, how to handle disputes that go in fact up and down a chain of charters, but where different arbitration tribunals are appointed at each stage, and there's no power, in English law at least, to consolidate proceedings. There have also been some very substantial problems arising from insolvencies, usually of charterers, but more recently, of course, O.W. Bunker. Those of charterers resulting in attempts to negotiate amicable terminations of fixtures, as well as liens on sub-hires and sub-freights, all problems rarely encountered 40 years ago. Linked are those cases, again new in type, which have involved insolvency coupled with performance guarantees and or shipbuilding contracts. One in which I was recently involved concerned a long-term charter which the charterers were entitled to cancel in certain circumstances, where the owners became entitled to terminate the shipbuilding contract. Issues had arisen as to what those circumstances are, and whether the owners were in fact entitled to terminate the shipbuilding contract. These issues involving interpreting both the charter and that contract. So I turn for a moment to consider what I call the players. That's us, really, and others. Another great change that I have observed, which is no doubt partly a symptom of globalization, is in the players, the owners, charterers, shippers, arbitrators, and others. For one thing, there seem to be fewer small operators, at least in proportion to the total market. The owner with one or two ships now seems to be a rarity, as is the small trader. Huge shipping empires, sometimes consortia, play a proportionately much greater part, as do substantial shippers and charterers, than before. Consequently, they carry much clout. And one of the effects of this is that although disputes still occur in their transactions, they are often in a position to bring such commercial pressure on their contracting parties that matters never go to arbitration or settle if they do. And speaking of settlement, I know that a number of owners, no doubt helped by their clubs, now look much more carefully than did their forefathers at the economics of fighting cases, not just balancing legal costs against the sums in dispute, but also taking account of internal management time and future relations with their fellow disputants. Again, this leads to cases that might otherwise have fought being settled, often before they go to arbitration. And one of the reasons for this is the education that many who are most active in the business now receive, as well as their general backgrounds. When I was at a club in the 1970s, many of the principals in owning companies were former masters or chief engineers, accustomed to keeping notes of deals done on the back of cigarette packets or small scraps of paper. Nowadays, their successors, often their children, have been to university, studied economics, got their MBAs, and they spend as much time watching and playing the financial markets as they do running their ships. There have been changes on other fronts relevant to shipping that couldn't have been imaginable 40 years ago. For example, the sale of the Baltic Exchange to Singapore, the substantial financial interest that certain countries have taken in others infrastructure and ports. To cite one instance, the majority shareholding taken by Costco in the Piraeus Port Authority a year or so ago. And speaking of Greece, one Greek ship owner has estimated that if the EU Commission's proposals in respect of competition in shipping are implemented, half the European fleet would move to Asia. If that were to happen, it would inevitably have a great effect on our business and its main locations, a subject to which I shall return. One phenomenon that I cannot overlook is that of piracy. This is a problem that's existed since ships first started sailing, but in past decades its level has increased remarkably. More recently in South Asia particularly, but not long ago off the coast of Somalia. And cases have arisen concerning not only the direct effects, for example, liability for hire and other expenses during the period a vessel is held by pirates, but also indirect issues such as liability for extra insurance premiums, the choice of route taken to reduce the risks, the cost of security measures, and so on. Once more, these sort of issues were never encountered before. So much for a look at some of the changes in the world of shipping, but what of the world of maritime arbitration? How has that changed in the past 40 years? Speaking from my own experience, primarily in London, I suppose inevitably, the changes have been huge. I've already, in reviewing some of the developments in shipping, touched on a selection of the changes, in particular in relation to the types of cases. But I've also seen cases which I can't imagine having occurred, at least with any frequency, in the 1970s, where ships are detained by port or even governmental authorities without any real justification. For example, at the time of writing this lecture, and so far as I know even now, an ongoing case of a tanker detained in Venezuela since September 2014. Everyone, absolutely everyone, agrees that no one concerned with that ship had anything to do with a certain fraud that got close to being committed in relation to her. She was detained originally as potential evidence, but both the prosecutor and the courts now agree that she is not needed in that respect. The problem is that neither is willing to take the initiative to authorize her release for fear of losing their job, or worse. And there have been cases of armed guards boarding ships in African ports before even any arrest proceedings have begun, often to ensure that the vessels in question do not sail because of cargo claims, which have often turned out to be grossly exaggerated, if not wholly spurious. Their presence, the presence of the armed guards, being used to coerce the owners into paying, rather than simply securing those claims. Now, such problems arise most commonly in states where the rule of law is not as apparent as many of us are accustomed to, often because of a dictatorship or a virtual dictatorship which is in place. Very recent history suggests to me that we may be moving into an era, even in the Western world, where authoritarianism, if not outright dictatorship, is once again the predominant rule. If that is the case, it will no doubt give rise to other, perhaps new disputes that we have to resolve, though the consequences for society in general are unlikely to be desirable. What has also changed enormously is the way in which arbitration is now handled, at least in London. My only other experience of any appreciable extent is in relation to maritime arbitration in Paris, where I've discerned some modest refinements, but not, I think, any fundamental shift over the years. And that is no doubt a tribute to the procedures adopted there and to the Chambre arbitrale maritime de Paris in particular. But in London, as I've indicated, there have been great changes. By the time I started arbitrating in 1974-75, there were the first signs of a shift towards where we are now, but they were very much only the first signs. Prior to that, in most cases, at least one, and in all likelihood, both parties would not have legal representation. Each would appoint an arbitrator and send its nominee usually a small clip of papers about the case with a covering letter outlining the dispute and that party's point of view. The arbitrators would exchange those files and pass them back to their respective appointers for comment. Those comments were then passed back. There might be a further round of short comments, following which the arbitrators would discuss the matter, and if they couldn't agree, they'd appoint an umpire to whom they would present the case as advocates. The umpire took over the case entirely and made an award. But all that has changed dramatically. For one thing, nowadays lawyers seem invariably to be involved on both sides. Detailed written submissions or statements of case are exchanged, with the lawyers battling for the last word, such that we not infrequently, although seldom necessarily, see demands for rejoinders, surrejoinders, and even further rebuttal submissions. The slender file of documents provided by each side in the old days has now become a number, sometimes a large number, of near-bursting ring binders. Thanks to the 1979 and 1996 Arbitration Acts and the greatly increased use of NYPE and the Asber Void Charter forms, the umpire has all but disappeared, although clauses requiring an umpire are still found. When it comes to it, parties are generally willing to agree that a third arbitrator, rather than an umpire, should be appointed. Until the early 1970s, hearings were relatively rare, and when they did occur, they tended to be short. The increased use of lawyers changed that, so that once when I started as a full-time arbitrator, I quickly found my diary full with back-to-back hearing fixtures, a situation that Cedric Barclay himself had experienced for some time, and which, as I have explained elsewhere, led to him becoming known as a respondents arbitrator because he could not offer early hearing dates. The pendulum has swung, however, and rather fewer oral hearings are taking place now, many of the cases being dealt with on documents alone. What has brought about these changes? I believe there are a number of factors. In what I might call my early days, many owners and charterers maintained substantial offices in London, often described as mere agencies, but no one was fooled by that, where there would be an in-house claims handler, often doubling as insurance manager. Many such people were old hands at the business. They knew their stuff, and they and their principals saw no need for outside help, beyond perhaps that of their club managers, at least for the average dispute. Threats of taxation and other economic considerations drove many such offices overseas, or led to a reduction in their size and importance. The old hand claims handlers were not replaced when they retired. Owners would more often turn to their clubs, and they in turn, because of pressure of work and other considerations, would more frequently involve solicitors, who would often instruct barristers. Now, it's a natural human tendency to do things in a way ways that are familiar to us. Lawyers are accustomed to court procedures, and so similar procedures began to appear more frequently in our arbitration. At the same time, many of the new guard, if I may so call them, of maritime arbitrators, that is those who started in the 1970s and the 1980s and are now the London establishment, themselves came from legal backgrounds, at least in terms of training, so they were familiar with and they found it easy to go along with more formal procedures. Whilst originally the increased involvement of lawyers had effects that were relatively mild, over time other factors intervened that led to a rather different situation. For one thing, senior solicitors found themselves increasingly required to spend time and energy marketing and managing their businesses as practices grew and became more competitive. So work was delegated to less experienced lawyers who were not, in my view, given the supervision and instruction that had previously been provided to younger lawyers. That led, I believe, to a lowering of standards. Another factor, of course, is the blame culture, as a result of which lawyers have become increasingly concerned about being sued by their clients in case if they lose cases, and therefore tend to argue every point that might conceivably be open, however poor the merits. In addition, the mid-1970s saw the introduction of timesheets in solicitors' offices. Now, previously, cases had been largely costed on a kind of look-sniff basis. How heavy was the file? How much work did the lawyers feel they had put in? How much was involved in the case? What was its importance to the clients? And perhaps above all, what result had been achieved? Now, with timesheets, all that changed. Now it could be seen exactly how much time had been spent on a case, how much, therefore, the client could be charged, and how much could be claimed from the other side in the event of success. Or rather, all that could be seen provided that the timesheets were filled in correctly, and provided also that work so recorded was reasonably done. But there is what I call the tyranny of timesheets, because hand in hand with them came targets for individual lawyers involved. Now, I challenge anyone accurately to account for every minute or even every 10-minute unit of their working day, especially given the complexity and resultant distractions of modern life. Faced with a target of billable hours, often involving a high proportion of a working day, failing which you will lose your job and faced with the fact that promotion will to a large extent depend on how many billable hours you can record, the temptation to be creative, at least, must be enormous. There is, of course, the old story of the lawyer who died rather young, arrived at the gates of heaven, and protested to St. Peter that he shouldn't be there because he was only 38, and thus too young to die. But, said St. Peter, we've checked your timesheets, according to which you're 138. Now, occasionally it falls to us London maritime arbitrators to assess the cost that a successful party is entitled to recover from the losing party. When I have to do this, I am frequently dismayed by not only the hours said to have been spent on a case, but also the number of individuals involved in each firm, a matter which I feel is bound to lead to substantial duplication. Further, I believe that the tyranny of the timesheet, coupled with the blame culture and the fierce competition for places amongst lawyers currently in London, and for all I know elsewhere, has another effect, that of unnecessary argument at inappropriate length and in unpleasant ways, which inevitably leads to responses in kind, thus generating further costly work as well as ill-feeling. Now, I'm not for one moment suggesting that any of this is done consciously. I don't believe that more than a tiny handful of lawyers, if any, sit down consciously thinking, how can I maximize my chargeable hours, or how can I churn this case to the maximum? But I can't see any other reason for the extraordinary amount and length of vituperative and ultimately non-productive correspondence that now occurs in London arbitration and, I believe, in litigation. Enough of that. I'm going to turn now to talk about the arbitrators briefly, although I will come back to the question of costs. Arbitrators have changed. My experience when working at the club all those years ago, and prior to that for a firm of solicitors, involved the likes of John Chesterman, John Selwyn, Ralph Kingsley, Dick Clyde, and latterly Donald Davis, and of course Cedric Barclay. While some of them, excluding in particular Cedric, had some legal training, they were all commercially very experienced, and in particular mature men. Then along came John Potter and Michael Mabbs, both middle-aged men from broking backgrounds. There were, of course, others, but they were less involved. Most, though, were in the strict sense of the phrase commercial men. Soon, however, young whippersnappers, like me, came on the scene and fairly rapidly took up arbitrating as a full-time occupation. 4 of the now successful arbitrators in London, all of whom had some legal background, were on average only 32 years old when they were first appointed, and went full-time at an average age of only 42. Now, this marked a sea change, for until that time, the accepted wisdom was that one could not possibly start arbitrating until one was 40. To a large extent, I think this change came about because of the increasing involvement of lawyers in the process. They, who obviously have a great, although not final, say in the choice of arbitrators, tended to prefer those they might perceive as being of their own kind, and who could deal with the increasing procedural complexities that arose, largely because of the lawyers' involvement. We're now, I think, seeing a further change in the composition of maritime arbitration tribunals in London. In recent years, a number of QCs have sought to act as arbitrators, perhaps because they have had enough of advocacy, or perhaps because the work was not there for them, or some combination of such factors. At the same time, some judges have retired from the bench and sought, mostly successfully, to develop practices as arbitrators. To an extent, this has effects that are likely to perpetuate and indeed increase the role such individuals play as arbitrators. For a claimant may appoint a QC, or former judge, as his appointed arbitrator. The respondent, wrongly thinking that this gives the claimant some kind of advantage, is likely to appoint a similar person as his nominee. If the case proceeds and a third person is needed, the chances are substantial that the party-appointed arbitrators will appoint one of their own profession as chairman, rather than a typical LMAA arbitrator, if there is such a thing. Now, to an extent, I believe this is occurring because of a shortage of other, more commercial candidates for appointment who are perceived as being suitable for arbitrator. I emphasize that qualification concerning perception because there are, as the LMA's list of aspiring arbitrators shows, a good number of candidates around. But for whatever reasons, it looks as if those who have the gift of appointment don't view them as favourably as those candidates might hope. It's often thought that full membership of the LMAA is a prerequisite to being appointed, but in my view this is not so. Many of today's most successful arbitrators, including myself, receive substantial numbers of appointments before becoming full members. In contrast, we have seen some full members who have never had any great success, sometimes despite strenuous efforts on their own part to promote themselves. An example of the first category, that is somebody who built up a practice before becoming a full member, is our very new member, Claire Ambrose, who has developed a substantial practice before she even applied to become a member of the LMAA. Another factor in the rise of QCs and judges, or retired judges, becoming arbitrators, may be that it's now relatively difficult to obtain permission to appeal against awards in England. So perhaps it's therefore thought preferable to get a tribunal that is considered as more likely to reach the right legal answer. I make no further comment on that. The potential downside, of course, is that such tribunals don't have the extent of commercial experience that others might have. Another disadvantage is the sheer increase in tribunals' fees that is involved. These colleagues charge hourly rates up to twice what a regular LMAA arbitrator might seek, and apply cancellation fees that are, by LMAA standards, breathtaking. I said a short while ago that a respondent faced with the appointment of a QC or ex-judge may wrongly think that the claimant thus has some advantage. It remains the case, although to a far lesser extent than some years ago, that parties occasionally believe that the arbitrators they appoint are somehow going to fight their corner. In the 1960s and the 1970s, that might have been true to some extent, but it no longer is. We look at cases impartially. It's no longer right for an appointing party to think of my arbitrator. This is reflected in the fact that the vast majority of decisions in London are unanimous. Dissents are rare, and in my experience reflect a genuine difference of view when they occur. Indeed, I recall laughing out loud in one case when I was chairman, when my colleagues discussing the matter after a hearing were having a very heated disagreement. Indignantly, they turned to me to say, "Why are you laughing?" And I pointed out that the owner's appointee was arguing for the charterer's case, and the charterer's arbitrator was arguing for the owner's case. So what, they said, quite rightly. And so I come to something which I have headed conclusion, is this progress, where next? So this is under the second part of my title, 40 years on, is this progress? Progress, of course, can mean different things. If it means simply going forward, as in going forward in time, then the answer to the question is obvious. Indeed, the question is pointless. But if progress is taken to mean improvement or movement towards some ideal, then I'm not persuaded that what we have seen meets those requirements, any more than I'm persuaded that the world has, in this sense, progressed in the past 40 years. That may be because, as someone has said, scratch any cynic and you will find a disappointed idealist, or as the contemporary American historian Mark Liller says, where others see the river of time flowing as it always has, the reactionary sees the debris of paradise drifting past his eyes. The world has substantially changed in the past 40 years, and with it, so have shipping and maritime arbitration. The latter, in London at least, has become substantially more formal and lawyer-controlled, and very considerably more expensive than ever it was. Given that arbitrators have to be paid, it may now be considerably more expensive than litigation, which these days it largely mimics. And we can't expect that the increasing use of professional lawyers and ex-judges as arbitrators is going to reverse that tendency. Indeed, the opposite is more likely. For my part, I find it difficult to characterize what has happened in our work as progress in any positive way. Looking more widely, it is right that a number of other centres have been established with a view to developing local maritime arbitration. So far, they don't seem to have been a real threat to London's preeminence, and it's possible, although very far from certain, that until, if ever, they develop substantial maritime sectors or clusters of their own, such as London presently has, they won't be able to develop very greatly. But nothing in this world remains static. Fortunes rise and fall, as do dynasties, kingdoms, empires, and, dare I say it, presidencies. It may be, for example, that the effects of Brexit and EU regulation would drive much more of the shipping sector to the east than has so far migrated there. If that happens, and if London arbitration continues to be as costly as it is, and if overseas centres can develop cadres of competent arbitrators and lawyers, and preferably economic and efficient procedures, London may be under some serious threat. Having said that, I know that 9 years ago in Tulane University, giving the William Tetley lecture, which caused a certain amount of upset amongst some of my New York colleagues, I suggested that within 10 years London might see a substantial reduction in the number of arbitrations it had, and that mediation and early neutral evaluation might be in the ascendant. How wrong could I be, yet again? As I said at the beginning of this lecture, prophesying is dangerous. On the other hand, as President Kennedy said, change is the law of life, and those that look only to the past or present are certain to miss the future. Or as advertisements for financial services have to remind us, past performance is no guide to the future. So, if I must venture a prophecy, it is the banal one that things will not stay the same. How about that? As to how in our world of maritime arbitration they may change, I can only guess, assuming, and it's a huge and probably false assumption, that in the next 10 years or so there is no appreciable sea change or step change or quantum leap in circumstances generally. I might speculate that maritime arbitration will continue to prosper, but will probably be more evenly spread than it is now between various centres across the world. However, I would also guess, on the same assumptions, that London will, despite its costliness, continue to dominate, although not to the extent it does now. When you see my paper, you will see an afterthought, which is very brief, about technology. I'm not going to read it now because I'm 9 minutes over time. But I will just read you a postscript which I wrote on the 13th of February 2017. I said, I realise that the deadline imposed for the finalisation of the printed lecture, mid-February, falls tomorrow, on Valentine's Day. I find the thought touching, for despite the cynicism and pessimism that some may discern in what I have written, the fact is, I have always loved this work and the world in which we operate, and it is that which has motivated me rather than material considerations. I hope you too enjoy such good fortune. And as I said at the beginning, thanks to the generosity, in fact, of the Hong Kong organisers of the last ICMAR, all 10 of the Cedric Barclay lectures, including, I fear, this one, are available in a bound volume, a copy of which awaits you now. Thank you for your attention, and I apologise for overrunning.
Thank you very much, Bruce, for this State of the Union. We will now have a coffee break until 11 o'clock, where we will be back with the plenary session here in this room about current developments in arbitration. After the lunch break this afternoon, this meeting room will be divided in two. We will build a wall. We will have a divider there, so there will be a meeting room over there and a meeting room here.